Good morning, good afternoon, or good evening, wherever you are. On behalf of the Department of Law, North Southern University, it is my utmost pleasure to invite you to this session on International Criminal Court. What is it? What is does and what it does and who works here? Our guest speaker today is Mr. Farhaan Ahmed, Associate Legal Officer, Chambers, International Criminal Court. But before I formally invite our speaker to deliver his speech, it is my pleasure to invite our department chair, Barrister Arafat Hosen Khan, to deliver his introductory remarks. Arafat, over to you. Thank you.
Thank you so much, sir. Thank you for giving me the opportunity to welcome everyone. Dear esteemed guests, distinguished faculty members, honorable colleagues, and respected and dear students. Good evening from a very winter evening from Bangladesh, and a warm welcome to NSU Law webinar. It gives me great pleasure to start this insightful session, which promise to be both informative and thought-provoking. Tonight, we are honored to host Mr. Farhaan Ahmed, Associate Legal Officer at Chambers International Criminal Court, as our esteemed guest speaker. The subject of discussion, the International Criminal Court, what it is, what it does, and who works there. I think one of the very interesting topic, and it would be very helpful for us, for our students, to understand how International Criminal Court works. The International Criminal Court stand as an example for justice, addressing some of the most critical issues in the global legal landscape. As we explore into working of the ICC, we hope to gain a comprehensive understanding of its function, objective, and the dedicated professionals who contributed to its mission. Mr. Farhaan Ahmed, with his wealth of experience, will guide us through the interesting session about the ICC, shedding light on its significance and how exactly it works. I extend my heartfelt gratitude to Mr. Farhaan Ahmed for gracing us with his presence and sharing his expertise. I also thank all the participants for joining us tonight, showcasing our commitment to academic excellence and intellectual curiosity. Without further ado, let us embark on this enlightening journey into the realm of international criminal law with Farhaan Ahmed as our guide. Thank you and enjoy NSU Law webinar.
Thank you, Arafat, for your kind remarks. Now, it is my pleasure to formally invite our speaker to deliver his speech. Farhaan, please.
Thank you so much, sir, and thank you so much, Mr. Khan, for all of the generous introduction. So for this presentation, I'll start with a discussion about what the ICC is and what it does, and then that I'll spend more of like 20 minutes, 25 minutes on that, and also go into a discussion about careers at the ICC, etc. And that will more go into the questions that the audience might have about careers and opportunities of working at the court or working with the court. So brief introduction about me. As mentioned, I'm Farhaan. I work as an associate legal officer in Chambers or the judiciary here at the ICC. So my work fundamentally entails working with the judges, providing them with all kinds of legal support, legal advice, so that they can make decisions based on law and reason, and provide them with all kinds of assistance that are needed with regard to drafting their reasons in their decisions. So starting off with the ICC, let's just go back a bit to where the court comes from. So the ICC the International Criminal Court applies international criminal law. And the starting point of modern or contemporary international law can be traced to the Nuremberg and the Tokyo tribunals, or the Nuremberg and Tokyo trials, the Nuremberg Charter, and then subsequently the Tokyo Charter, where a lot of the crimes that we still apply today were created. The crime of crime against humanity, at that time also the crime against peace, which now has morphed into the crime of aggression, were charged and prosecuted during the Nuremberg and Tokyo trials. And this was in the mid to late 1940s, early 1950s. At around the same time, we also had the negotiation and adoption of the Genocide Convention within the UN in 1948. Genocide Convention codified the law on genocide, the definition of the crime of genocide, and in a way created the crime of genocide in law, at least. But after the 1950s, early 1950s, late 1940s, there was a long gap or hiatus in the development of international criminal law, at least from the judicial standpoint. Of course, there were academic works and there were advocacy on various aspects. It's only only when we come to the 1990s, early 1990s and mid 1990s, when we have the genocide in Rwanda and the atrocities as the result of the breakup of the former Yugoslavia, that we see the UN Security Council moving to set up two separate ad hoc international criminal tribunals to try the perpetrators of genocide in Rwanda and to try the perpetrators of atrocities in the former Yugoslavia. And the first one was called the ICTR, International Criminal Tribunal for Rwanda, and the second one was called the ICTY, International Criminal Tribunal for former Yugoslavia. Around the 1990s, there was also this impetus to move towards the creation of a permanent international criminal court, because the ICTY and ICTR were ad hoc tribunals, ad hoc in the sense meaning temporary tribunals. They were supposed to only investigate and prosecute specific crimes in Rwanda and former Yugoslavia. And their mandate was going to end when the prosecutions ended. And basically the ICTY and ICTR, which later on had evolved into what we call the International Residual Mechanism for International Criminal Tribunals, is basically closing down. So it's going to end in the next couple of years or so. But there was this need to have a permanent international criminal court so that either UN Security Council or the UN General Assembly or some other international body would not have to continuously act in a political manner to set up new tribunals whenever there is an atrocity. And all of this culminated into a conference in Rome in 1998, where 120 states adopted what we call the Statute of the International Criminal Court. In short, we call it the Rome Statute. So it was a treaty that was adopted by 120 states, which codified the various laws and the legal framework of a permanent international criminal court. The Rome Statute entered into force on the 1st of July 2002, and that is the point when the ICC began functioning and came into existence in a formal manner. At present, the ICC has 124 states parties. Late last year, Armenia was the 124th state party to sign and ratify the Rome Statute. In the meantime, just to let's say take a small detour, there were other international criminal tribunals that were set up, which were, we cannot say ad hoc, but hybrid in the sense to try specific atrocities in specific countries and regions. We had the Extraordinary Chambers of the Courts of Cambodia. In short, it was called the East CCC, to try the perpetrators of the atrocities during the Khmer Rouge regime in Cambodia. Then we also had the Special Courts for Sierra Leone to try the perpetrators of atrocities during the Liberian Civil War, as well as the Civil War in Sierra Leone. We also had certain special other tribunals, in the sense that we had a tribunal called the Special Tribunal for Lebanon to investigate and prosecute the assassination of then Prime Minister of Lebanon. And at present, we have currently a functioning ad hoc tribunal called the Kosovo Specialist Chambers, which also investigates and prosecutes atrocities committed in the former Yugoslavia, but specific to the territory of Kosovo and perpetrators who emanate and come from Kosovo. And all of these ad hoc tribunals, at least during the early days of the ICC, played a very important role in developing the law and jurisprudence of the court. The ICTR and ICTY specifically on the crimes of genocide, war crimes, as well as crimes against humanity, defined a lot of the crimes, the elements of the crimes, what's required for these crimes to be perpetrated, and the nuances of these crimes. And a lot of those lessons that were learned were adopted into the Rome Statute, and subsequently also inculcated into the jurisprudence of the ICC. Now, there are certain unique aspects of the ICC as opposed to, let's say, the other ad hoc tribunals. Firstly, of course, the ICC is a permanent international criminal court as opposed to any other ad hoc tribunal. All of them, starting from the ECCC to the ICTR, ICTY, STL. STL already closed down technically. So all of these courts and tribunals would close down at some point in time, but the ICC was envisioned as a permanent institution. So the first characteristic that I would talk about is the fact that the ICC functions on the basis of individual criminal responsibility. What this means is the court only investigates and prosecutes individuals, or what we call natural persons. The court does not prosecute states or corporate entities. Of course, the court can investigate individuals within states and corporate entities, heads of states, heads of corporate entities, but the state itself or the corporate entity itself is not investigated or prosecuted as such by the court. It's individuals within that state, the generals, the presidents, the prime ministers, the CEOs of corporate entities who can be individually tried and prosecuted by the court. Second, the court has jurisdiction over 4 specific crimes: genocide, crimes against humanity, war crimes, and the crime of aggression. These are the 4 specific crimes over which the court has jurisdiction and nothing else. And it is defined by the statute and also in many ways limited by the statute. By statute, I mean the Rome Statute, the treaty that was adopted by now 124 states. So thirdly, like I said, it's a treaty. The court is based on a treaty. So technically, it is a treaty organization or a treaty-based organization. So the laws, the functioning of the court, the legal framework, the jurisdiction of the court, all of it is defined by the treaty or defined by the rules and regulations of the treaty, which were adopted through delegated powers of the treaty. And the treaty is, in a way, administered by what we call the Assembly of States Parties, or the ASP. The Assembly of States Parties is, in many ways, is like the General Assembly for the ICC. They meet every year at the end of the year around December. They adopt amendments, new rules, regulations for the court, adopt the budget for the court. They are responsible for general administration of the court, at least from, or oversight of the court. Fourthly, the court, and this is also very important, when the court was envisioned, as opposed to other ad hoc tribunals and ad hoc or hybrid tribunals, the court was envisioned as a court that would be complementary to domestic legal systems. So what this means is the ICC is not envisioned as a court that would replace domestic courts. rather complement domestic courts. In other words, it is only when domestic courts of a particular state or territory either is unwilling or unable to investigate and prosecute an atrocity or an alleged crime, it is only then does the ICC step in. So if a state or a country has a fully functioning domestic legal system, which is genuinely investigating and prosecuting alleged crimes of atrocities which fall within the court's jurisdiction, then the ICC in those situations will not get involved. And this complementary nature plays out all throughout the assessment of investigations, consideration of whether ICC should get involved in terms of decision-making by the prosecution as well, whether an investigation is merited or not in a particular situation, which we'll come to later on as well. Okay, moving on to the structure of a courtroom in general at the ICC. So I'm not sure if you can see my mouse, but at the very end of the courtroom, you have the audience, the public gallery where audience can sit and attend a trial, and trials are public. So it can be not only attended in person, but also can be viewed live through the court's website. And then the view that you're getting is the view that the judges would get generally of the courtroom. So you have the box right in the middle, which is the witness box. Generally, when witnesses testify, they sit there. And on your right, closest to you would be the prosecution who would sit. Further from the prosecution, you would have the victims on your right. And on your left, generally, you'll have the registry. Sorry, the defense. And further from the defense, on your left, in many situations, you could have the registry when the registry is required to make submissions. And sometimes it could be a state as well, representative of a particular state, especially when there's issues of jurisdiction being discussed or dealt with by the chamber. You will have a representative of the state making submissions on behalf of the state. Moving on. Okay, so how are investigations started or initiated? So if you look at the ICC, although the ICC technically seems like one organization, it is actually an organization composed of three separate, in many regards, independent organs. We have the Office of the Prosecutor, which is responsible for investigating and prosecuting the crimes. We have chambers, where I work, which is the judiciary or the judges. And then we have the registry, which is a neutral organized entity responsible for the general functioning, administrative support, the logistical support for the court. For example, they provide the court officers, they provide the necessary services that are needed to make the court function efficiently. Help to victims, help to witnesses, assistance to victims and witnesses, transport of victims and witnesses, etc. Running the detention center of the suspects, etc. All of that is basically the purview of the registry. So it is the Office of the Prosecutor who opens investigations. And the Office of the Prosecutor can open investigations in three circumstances. First, if a particular situation means an instance of alleged atrocity, is referred to the Office of the Prosecutor by a state party, the Rome Statute. So if certain crimes have alleged to have happened in state X, and state X is a state party, and state Y is, let's say, is also a state party, state Y can refer the situation in state X to the ICC. Second, the Office of the Prosecutor can also open investigations on the basis of a request or a referral from the UN Security Council. And these UN Security Council referrals are adopted under Chapter 7 of the UN Charter by a UN Security Council resolution or through a UN Security Council resolution. Then the Office of the Prosecutor can also open investigations by their own initiative. What this means is generally what happens is in these situations, the Office of the Prosecutor generally continuously receives information, and we call, in legal terms, we call them communications from NGOs, civil society organizations, and other entities about alleged atrocities or alleged crimes that may have taken place around the world. And on the basis of that information, if the Office of the Prosecutor thinks that there may be enough grounds to open an investigation, then what the prosecutor does is they start or initiate what we call a preliminary examination. So a preliminary examination is basically an investigation before an investigation. Basically, it is to check whether a full-fledged investigation is actually worth it or not. Because of course, a full-fledged investigation requires human resources and other resources that needs to be put in. So on the basis of the preliminary examination, if the prosecutor thinks, yes, there is enough information to open a full-fledged investigation, then they approach the judges, in this case, the pretrial chamber, for a full authorization. So the pretrial chamber, again, looks at the information submitted by the prosecution, maybe hears from the defense and the victims, and on the basis of that, can authorize the prosecutor to open an investigation. And this has happened, for example, in the case of Myanmar, Bangladesh, in the situation of Myanmar, Bangladesh, where the Office of the Prosecutor first opened a preliminary examination, and then on the basis of the preliminary examination, sought the pretrial chamber's authorization to open a full-fledged investigation. And currently, the investigation is ongoing. Just going back to the UN Security Council referrals, the UN Security Council referrals have happened twice with regard to Darfur, Sudan, and with regard to Libya. In addition to the legal framework or legal requirements to open an investigation, the prosecution also, as well as subsequently the court, also have to consider other issues and other legal requirements before an actual investigation is open and, let's say, deemed to be legally viable. Firstly, the court can only investigate and prosecute crimes that have taken place after the 1st of July 2002. This is a date that is provided by the Rome Statute, and this date is there because before the 1st of July 2002, the court did not technically exist. Then we have also the requirement of jurisdiction with regard to territory or nationality. The court only has jurisdiction over crimes that have been committed on the territory of a state party to the Rome Statute or by a national or citizen of a state party to the Rome Statute. But this territorial or nationality jurisdictional limitation does not apply to UN Security Council referrals. So for UN Security Council referrals, like I said, with regard to, let's say, Libya or Darfur, Sudan, neither Libya nor Sudan are actually states parties to the Rome Statute. However, because of the fact that it's a UN Security Council referral and adopted under Chapter 7 of the UN Charter, all states or all member states of the UN are obligated to cooperate or obligated to abide by it because it is a binding resolution. And that also gives the court the jurisdiction with regard to territory or nationality. And therefore, no specific territorial or nationality jurisdiction needs to be created through the Rome Statute as such by the state or the person emanating from a state that is a party to the Rome Statute. Then, when we are looking at when the alleged crimes are being assessed, the prosecution also has to assess, and as well as the pretrial chamber has to assess whether the crimes that have been alleged actually amount to either war crimes, crimes against humanity, or genocide. Because, for example, not all instances of murder are war crimes. Only when a murder or a rape or a torture is committed in the context of a war between belligerents or one belligerent killing a prisoner of war, only in those circumstances is that act considered to be a war crime. So for example, if two neighbors are fighting each other, let's say there's a war going on outside, and one neighbor kills the other neighbor, that is not a war crime because that has no connection or nexus to the armed conflict that is going on outside. So it has to be committed in the context of an armed conflict. Generally, it can be an international armed conflict, or it can be a non-international armed conflict as well, between a sort of a civil war as well. Similar requirements are applicable with regard to crimes against humanity as well. For crimes against humanity, they must be committed in the context of a widespread or systematic attack against a civilian population. And this is what we call a contextual element. So unless a particular murder, a particular torture or rape does not have any connection to a widespread or systematic attack against the civilian population, it will not amount to a crimes against humanity. For genocide, there has to be intent to destroy whole or in part a particular group. So all of these assessments need to be made for, let's say, when the prosecution is investigating a particular instance of murder, rape, or torture, to check whether they qualify as one of the crimes within the court's jurisdiction. Then there are three other assessments that are made. Firstly, to check whether the crimes are grave enough or not, whether the crimes that have been alleged are serious enough or not. Again, this is required by the statute itself. So only serious instances of crimes or alleged crimes would be investigated and then subsequently prosecuted. Then, of course, there is a test for complementarity to check whether the crimes are actually being genuinely tried or prosecuted or investigated at a national level or not. If, again, at a national level by the domestic prosecution or domestic courts, if the crimes are being genuinely prosecuted or investigated, in that case, again, the court will not get involved. Lastly, there's an assessment also made with regard to whether an investigation by the court through the office of the prosecutor would serve the interests of justice. Now, this interest of justice is assessed on a case-by-case basis. It depends upon the circumstances of the specific case or situation. However, for example, there can be situations where the ICC getting involved with its retributive, adversarial form of justice may not serve the interests of justice. This can happen in situations of post-war, post-conflict countries, territories where the states or the territories have adopted their own transitional justice mechanism. So maybe they are rehabilitating former perpetrators of genocide. So for example, Rwanda, after the genocide, has and continues to implement rehabilitation programs, other transitional justice programs to rehabilitate former genocidaires, former members of the Interahamwe, with a group that was responsible for a lot of the killings that happened in Rwanda. A more recent example is Colombia. The country of Colombia very recently signed a peace pact with the rebel group FARC and brought the FARC into the political fold and has adopted a transitional justice mechanism which involves trials, which involves rehabilitation, which involves reparations, compensation, and it's called the Special Jurisdiction for Peace, SJP. And as a result of that, actually the prosecution was investigating the crimes and atrocities, alleged atrocities in Colombia. But as a result of Colombia adopting this transitional justice mechanism and its own localized form of justice, the prosecution subsequently ended its investigation in Colombia. So that assessment for whether a particular investigation serves interests of justice is made, and sometimes the court getting involved may not serve the interests of justice. Currently, there are 3 preliminary examinations ongoing. We have Nigeria, we have Venezuela 2, and the DRC 2. You have the 2 here because this is the second set of investigations or preliminary examinations technically. So DRC is the Democratic Republic of Congo. There was already an investigation, as a result of which there were arrest warrants issued and prosecutions done. And now there's a second set of investigations. Technically, in a way, you could say a second investigating a different set of facts. And that is why you have the two there. There are 12 ongoing investigations across the world. You have the investigation in Bangladesh, Myanmar, ongoing investigation in Afghanistan, Palestine, Philippines, Venezuela. You also have Ukraine as well. Okay, coming to arrest warrants and summons to appear, and then I'll move on quite quickly. So with regard to arrest warrants, the prosecution, during its investigation or at the end of its investigation, if it thinks that, yes, there is enough reasonable basis to think that certain people have committed certain crimes, then the prosecution requests the judges to issue either a warrant of arrest or a summons to appear. Generally, summons to appear are issued when it is likely that the alleged suspect would appear before the court voluntarily. And when it's unlikely, which is in most situations, the court, basically it's the pretrial chamber who's responsible for issuing of arrest warrants. The pretrial chamber will issue a warrant of arrest. And the ICC fundamentally relies upon cooperation of states for implementation of arrest warrants. So the ICC does not have a police force that goes out and arrests people and brings them to The Hague. It is the states who have a treaty obligation under the Rome Statute to, when they receive information of the existence of an arrest warrant against a particular individual, it is their obligation to arrest or apprehend the person and then subsequently transfer them to the ICC. Generally, ICC arrest warrants are confidential, or what we call under seal or secret. Only in rare circumstances would the arrest warrant or the existence of an arrest warrant be made public. So at any point in time, there are more arrest warrants in existence than what is known to the public. At present, just to give you a brief overview, we have 6 ongoing cases. We have the case of Mr. Said Abdul Kani, which has the prosecution case ongoing. There was an adjournment in the case because of certain medical reasons, and the case is going to restart in the next week or two. Then we have the case of Mr. Abdul Rahman. In case of Mr. Abdul Rahman, the defense case is currently ongoing, but there's an adjournment in the defense case as well. But after the defense case ends, of course, then the court will move on to closing arguments. And we have the case of Mr. Yakatom and Mr. Gaisona. That case as well. It's a case which has 2 defendants. So it's one single case with 2 defendants. And that case is also at the defense case stage. So the defense is making its case in that case. Then we have the case of Mr. Al-Hassan. Case of Mr. Al-Hassan, the trial has ended. The trial chamber is currently deliberating on its judgment of conviction or acquittal. The judgment could come out anytime in the next few days or weeks. Then we have the cases of Mr. Ongwen and Mr. Taganda. In both their cases, they were convicted by the trial chamber, and then their convictions were upheld by the appeals chamber, and both their cases are currently in the reparations stage. So one unique thing about the ICC is that at the ICC, victims, through their legal representatives, participate at every stage of the proceedings, starting from arrest warrants all the way up to the appeal stage, the reparation stage, where they play a very important role. What reparations means is when a person is convicted, after conviction, after sentencing, the trial chamber issues a separate order ordering the convicted person to pay a certain amount of money as reparations to victims of the alleged crimes, of the convicted crimes, crime for which the person has been convicted. And then the trial chamber also sets out the modalities in which the reparations are supposed to be paid out. It could be, for example, symbolic reparations in the form of building a memorial or infrastructure, for example, building schools, water pumps, or providing some kind of support, or it could be even monetary handouts as well. So this reparations mechanisms is very important, let's say, unique creation, development of the ICC, which was not present in the ICTY, ICTR, or any of the ad hoc or hybrid tribunals. There are situations, and most of the situations are, in that case, it's true that the defendants or the convicted persons may be indigent or may not have sufficient funds to pay the reparations, because the reparations will be in millions. So in that situation, the court has what we call a trust fund for victims. The trust fund is composed of voluntary donations from states parties. And when the convicted person does not have the sufficient financial means to pay the reparations, the trust fund steps in with the funding and logistical and administrative support with regard to implementation of the reparations order of the trial chamber. There's a detention center here at The Hague as well, where persons, while they're standing trial, are detained. And it's very important to differentiate this with a prison, because when a person is convicted, they are actually transferred to a national prison. So generally, the court has agreements with various states. So once a person is convicted, the court gets into negotiations. The registry primarily gets into negotiations with states who might be willing to take the convicted person and make them serve their sentence in the national prison system. And that is what happens. So the detention center, because it's a detention center and the persons who are kept at the detention center are not technically convicted persons, they have their rights and privileges and standards are very different to someone who has been convicted of a crime. And that's why the detention center also meets the highest standards. It is basically in the same building where the ICTY detention centers were. Now the Kosovo Specialist Chambers Detention Center are situated there as well. It's part of the Dutch prison system, but it's a separately function and run entity. Okay, lastly, just to give you a brief overview of the statistics, it's actually almost 22 years. There have been 31 cases, 47 defendants, 10 convictions, 4 acquittals, and over 16,000 victims who have been represented. And that the representation of the victims is actually a very important, let's say, aspect of the court's work and functioning in terms of providing victims with closure and a sense of justice. And of course, also these statistics does not represent the fact that because of the complementarity system, many states, territories, because of the existence of the ICC, have been more proactive in investigating as well as preventing and subsequently, of course, prosecuting alleged atrocities or implementing laws to prevent the commission of atrocities. Looking at the future, there are certain, of course, everyone accepts that there are shortcomings because of various reasons, and there are places where the court can improve, especially in terms of cooperation from states, in terms of apprehending, arresting, and transferring suspects, as well as providing relevant and requisite amount of funding and resources for the court to conduct its investigations. So if you look at the funding for the court, for example, over the last 20 years, the court's budget cumulatively has been $2 billion, which is basically 1 year's budget of the New York police force. So it is very limited in that sense. Then, of course, there's a challenge with regard to universality, considering the fact that there are still around 70 states who are missing, and also certain key players, key, let's say, P5 members of the UN Security Council who are also missing in terms of membership of the court. And lastly, in terms of demand for justice, this is where I think that the court has made a great impact, is this in the sense that for a large part of human history, committing rape, burning down villages, murdering innocent civilians, women and children, raping, torturing was normal during war. It was taken as accepted. And it was only after let's say after the First World War, we started to think about the fact that, okay, war cannot be this, right before the First World War, actually, we started to think about the fact that war cannot be this brutal. We started to ban some use of some weapons. And then, of course, after the First World War, Second World War, collectively, we, as a civilization, we thought, okay, committing these acts are criminal. But since then, up till, I would say, the establishment of the ICC, or a bit later as well, justice for atrocities were more of a hope. Because if atrocities were committed, such as in Rwanda or former Yugoslavia, or even in Bangladesh in 1971, we could only hope that either if the UN acted or some other entity acted and set up a justice mechanism, or then we might get justice, or then the victims might get justice. But after let's say, the establishment of the ICC and after ICC began its functioning, there has been a change in the psyche, at least what I've seen, in the sense that now we don't hope for justice, we expect justice. We demand justice. That's why there's a lot of criticisms that come towards the court, come from the place of people, not that they don't believe in the court or not believe in international criminal justice, rather they expect it to do more, which means that at least collectively as a civilization, we have become, let's say, more civilized. And we expect justice, we demand justice. And that, I think, is a great contribution of the court over the last, let's say, 2 decades. Just regular disclaimer, follow the court, support its activities. Now, again, what I would like to do is talk to you about careers at the court, as well as answer questions as well. So if there are any questions, we can deal with them. And then also I'll discuss what are the opportunities that may be available to new graduates and in people who want to build careers in international criminal law or international law as such as well.
Thank you, Farhaan. Thank you for very informative speech. Our topic has been, I would say, quite broadly selected, but I think you have covered it very well, as always. We have several questions, but before I move to those questions and I put them to you, maybe you could talk about career aspect, as you have just mentioned, maybe for 3-4 minutes, please.
Yes, sir. Thank you, sir. So with regard to careers, I accept that the ICC is based in Europe, in The Hague, and it's thousands of kilometers away from Bangladesh, or in many other, let's say, global South countries. And that is a hurdle to entering into careers in various international courts and tribunals. ICJ is also based basically here in The Hague. And with regard to ICC, for example, there are funded internships. So be on the lookout. Sometimes I also share them as well for funded internship positions, which are available at the court. When I started initially at the court, I also came to the court on a funded, it was a visiting professional placement, which is technically someone who's working already, who has at least 2 years of work experience, who can come. And of course, there are internships who are for students who have just graduated or are about to graduate. And I came on a funded position because, of course, I could not have afforded to come to the court. And within the court as well, we have been having this discussion not only at the court level as well as the level of the Assembly of States Parties, of how the court can become more inclusive or geographically representative. So take a look out for those opportunities, apply for those opportunities. Also, a lot of people are not aware that there are other opportunities within the court which are not legal. So there are investigators positions, analyst positions, there are positions for human resources, there are positions available for positions available for IT, computer engineers, admin assistants. So there's a plethora of opportunities because it's technically an international organization. So all of the, let's say, resources, human resources that are required for international organizations functioning, technically there are jobs available in all those areas. So in terms of starting off at a career, for international law, it is getting more competitive. I do confess that. And internships more or less have been the point of entry for a career or let's say a job at the ICC, not only the ICC, the ICJ, or the other tribunals as well. So since most of your students, I would say target the funded opportunities. In that sense, of course, study as much international criminal law as possible, because these internship positions have also become more and more competitive, and especially the funded ones, because there's a lot of competition from across the world for those very few funded opportunities that are available. So gain the knowledge of international criminal law, follow what the court is doing, follow the judgments, decisions of the court. You can also look at the hearings. There's an ICC moot that takes place every year. So participate in the ICC moot. Basically get awareness and learn as much as possible of the court. And then when you are here, when you apply for internship, of course, you can fund yourself as well. I mean, there's nothing wrong with funding yourself and coming and doing an internship. And after that, of course, since if you are good, people will see it. And then, of course, that helps you with finally, let's say, getting into a career or getting into some kind of employment at the court. The process takes some time. It's almost a year-long process. If you apply for, let's say, the P2 level, which is a level of professional level, legal officer level, you have to give a written test, and then subsequently there's a competency-based interview, and then subsequently you get put on a roster, and then you get called at some point in time. So read up on the process, read up on, the court more or less follows the mechanism for recruitment that UN implements as well. So UN has competency-based interview system, and how UN conducts its, let's say, the recruitment process, the ICC more or less reflects that as well. So it would help if you read up on it. And unfortunately, internships are the entry point. Internships, I mean, very few people get full-time, let's say, recruited in full-time positions who have not been to the court before. It is a logical sense as well, because you would want someone who has already been here, knows how things work, rather than recruiting someone who has, according to you, at least on paper, maybe have no idea of working in a multicultural, multinational, multi-ethnic, very specialized environment such as the ICC. So those aspects matter. So even if you, let's say, don't do an internship at the ICC, maybe go and try to get experience in places where you get, let's say, exposure to multinational, multi-ethnic, multicultural work settings, or places where you'd get expertise and knowledge in international criminal law, or if not international criminal law, just criminal law. Because 90% of what we do at the ICC, especially, let's say, in trial, as well as pre-trial, is criminal procedure. How evidence gets excluded, included, admissibility of evidence, exclusion of evidence, how witness statements are supposed to be taken, how cross-examination of witnesses take place, how examination of witnesses take place. It's a lot of procedure. And if you have experience in criminal procedure, that also helps you get better adapted to international criminal practice. There are also opportunities in defense teams as well. Deans are more independent. Defense lawyers are more independent, but they also hire interns, legal assistants, case managers. So there are opportunities, but you have to be on the lookout for it, and you have to follow the court and be aware of what the court is, because even as interns, because of the competitive nature, people expect you to know a lot of things already, rather than interns, as I would think, should be like learning opportunities. It is unfortunately not in many regards. Of course, you learn, but it's expected that you will have some background knowledge already when you come to the court for an internship. Yes. Sorry, sir, I took longer than 5 minutes.
No. Thank you so much. So I think that question is already addressed by you, but if you have anything to add, one of our recent graduates, Saire Nazabi Saim, she has asked that apart from the paid visiting professional positions, internships, are there any other funded opportunities at the ICC? I would assume that you have covered, but if you have anything to add, maybe you could add it, please. Thank you.
No, of course, jobs are funded, but other than that, in terms of getting experience, no, it's internships and visiting professionals.
Thank you so much. Now, I'll pick from the answer that you have given to the last question in terms of evidence. So as I understand it, some of our students, particularly fresh graduates, they assume that domestic experience is not valuable. But as I often tell my students, although you know how shallow my knowledge of international criminal law is, but as I understand it, that international criminal law is a combination of international law as well as criminal law in many ways. So if you have some experience in our national prosecution service or maybe as a defense lawyer, does that add any value? And with that, I would also add another question from another alumnus of our law department, Gianni Masina Hawk. She asks, what is the evidentiary burden with the office of the prosecutor has to comply with in the pre-trial chamber in order to successfully open an investigation? So your views on them, Farhaan, please.
So starting with the first question, experience in any domestic criminal system is very helpful, especially if you're working for the prosecution. But of course, where I work in chambers as well, if you're working in trial, it's helpful. But again, in chambers, because there's an international law aspect as well, and because you're advising judges, you have to have let's say a broader knowledge base. It's not as important, but if you are working in prosecution or in defense, I think that can make and break a good lawyer or a good advocate at the international level. So domestic practice level, because at domestic practice, what you learn advocacy, and that is important. And if you're a good advocate, you can learn the law, and you can find the law, and you can learn it. You can learn the procedure of a different system, and proceed more or less criminal procedure across the world are, at least at the base level, are similar. So that helps you. That will definitely help you, at least if you know that you're not supposed to ask leading questions during cross-examination, or what leading questions are, or the art of conducting a cross-examination. Those things will definitely give you a leg up if you're working in the prosecution or defense, even in chambers. And coming to the question that Ms. Hawk asked, regarding evidentiary burden of the ODP with regard to getting an authorization to open an investigation. There, the evidentiary burden is very, very low, because there are multiple levels of, let's say, checks and balance. So first, we have authorization to open an investigation. Then, of course, there is another assessment by the pretrial chamber when, let's say, arrest warrants are issued. And then, of course, then another assessment by the pretrial chamber when the suspect is surrendered and charges are confirmed. So when charges are confirmed, the evidentiary burden is basically reasonable basis to believe that crimes may have been committed. So when we come to opening investigations, at the opening investigation level, because technically we don't have suspects, we just have information that crimes may have been committed. So all the court needs to be satisfied of is there are multiple allegations of crime, and prima facie, it seems that these crimes amount to one of the 4 crimes that are within the court's jurisdiction. So it's very low, and it's assessed on a case-by-case basis. And I don't remember the exact terminology that the chamber uses, but it uses different terminology in different situations. Yeah, that's the best answer I can give you. You can email me and I can give you a better example from the decisions itself, quoting the decisions. But right now, on top of my mind, I cannot give you the exact terminology, but it's very low.
Thank you for that answer. The next question that I would like to put to you is from another alumnus, Siren Azabi Saim. Her question is, seeing the string of cases that have been dealt by the ICC, many legal minds believe that most of the cases are against African state leaders. Since the ICC prosecutor can suo motu, taking cases for full-fledged investigations, can they avoid such coincidence or speculated quote-unquote bias, or perhaps can widen the geographical area of investigation? Thank you.
Thank you, sir. Yes. So at the court, we are all aware of how it looks, how, at least if you go back, how this page looks. And there are multiple reasons why it is the way it is. Of course, the prosecution is doing a lot to, and has been doing a lot to not focus on Africa in that sense. But the issue is, it's not a coincidence. It's a outcome of circumstances, because Africa was and is the biggest supporter of the ICC. Africa has the largest number of states parties to at the ICC. Africa has been one of the earliest, let's say, adopters of the ICC and the Rome Statute. So if you look at, let's say, the cases of Mr. Ongwen, it is from basically an referral, self-referral by Uganda back in 2005. Uganda referred itself to the court for investigation back in 2005 for crimes that occurred between 2002 and 2005. So many of these cases are results of actually states cooperating with the court and referring their own situations to the court for investigation and prosecution. And these cases are also a reflection of the fact that states in Africa, Uganda, Chad, Democratic Republic of Congo, Central African Republic, have been extremely cooperative in terms of not only providing access for investigation, but also apprehending and transferring alleged suspects and individuals against whom warrants of arrest have been issued. So And also, it's a result of the fact that, like I said, since Africa was the early adopter of the court, and at the court, a case it takes a long time for a case to come to fruition. So investigations, like I said, in the case of Mr. Ongwen, started back in 2005. In the case of, let's say, Mr. Abdurrahman, started back in 2006. And now these cases are in trial in 2023, 2020, 2022, 2023. So it takes 20, 30 years, or at least 20 years, for cases to come to trial. And since Africa were the early adopters, most cooperative in those early days, these cases have now come to trial. But of course, over the 20 years, more states have become cooperative. Now we have investigations. There's investigations ongoing in Myanmar, Philippines, Ukraine, Venezuela. There were investigations in Colombia as well. And those cases, at some point in time, those investigations may lead to arrest warrants, and those arrest warrants may lead to apprehensions, arrests, and transfers, and subsequent trials. So it takes time. And if this is the picture that you're getting, it's basically a picture that dates back to 20 years ago. Why 20 years ago, a lot of states, and especially African states, were like more cooperative. And of course, there is a colonial aspect to this as well. I mean, historically, Africa has been plagued by conflict because of colonial, post-colonial domination, influences, hegemonic power plays. And many of these conflicts which have resulted in these cases do emanate from these kinds of post-colonial conflicts. And that is how it is. I mean, but the court, does that mean the court, let's say, actively targets Africans? No. It's just that it's just African states are just much better at cooperating. And almost all of the African states are member states of the court. The big nations, Nigeria, South Africa, Kenya. There were investigations in Kenya as well. So because of the cooperation, we have these cases. And it's actually a reflection of how Africa as a continent and states in Africa believe in the court and cooperate with the court. But of course, for other people from other side, it also shows that the court may be interpreted as court is targeting Africa, but it's not. It's just because of the legal framework limitations, it seems like that.
Thank you, Farhan. So maybe we could call it a confluence of several factors, legal and historical. Maybe I'll put it that way. The next question that I would like to put to you is from one of our undergraduate students. I think this is slightly based on an idea that any different views or any different judgments or dissenting opinions are sometimes illegitimate. But nonetheless, I'll put the question to you that ICC judges have been divided in their application of the law, resulting in inconsistent judgments and contributing to some sort of uncertainty in the definition and development of legal norms in the field of international criminal law. So maybe you and I would differ with that proposition, but I don't know how you take it. And based on that, the question asks, what reforms or mechanisms could be introduced perhaps to remedy this? Thank you.
That's an interesting question. It's difficult to discuss about inconsistency in abstract because you have to take either, was it regard to defining civilians in war crimes? Was it regarding defining what we mean by an armed attack in case of crimes against humanity? So if you talk about inconsistencies generally, on top of my mind, I cannot think of anything. But one way of dealing with these inconsistencies, let's say, is to provide more clarification, amendments to the law itself, to the ICC's, the Rome Statute and the rules and regulations, the elements of crimes, so that these inconsistencies don't take place. And also, I mean, in many situations, because the ICC is, we have the pretrial chamber, the trial chamber, and then on top we have the appeals chamber. And appeals chamber's decisions are binding on the pretrial chamber and the trial chamber. So when appeals chamber rules on something, and the appeals chamber is generally consistent, it is binding from henceforth on all trial chambers and all pretrial chambers. So in that way as well, if something goes to appeal, it provides consistency and certainty, because from that point onwards, unless the appeals chamber creates a new caveat or a new carve out, that law, the way it is defined or decided by the appeals chamber, will be binding on all future trials as well as pretrial chamber decisions. So that there's this internal mechanism itself that provides consistency, or at least clarifies differences and issues or competitions between different points of view. But of course, there can be dissenting opinions. I mean, dissenting opinions can always be there, and that's fine. That in a way also shows that the court functions well, and there is a lively discourse about how the law should be or where it should develop. And yeah, that's the best I can do in terms of just discussing inconsistency in that general sense. Maybe if you have a specific example, I can.
Thank you, Farhaan. Thank you.
Sorry, sir.
As Raghib studies more, as he progresses, maybe he would know that sometimes dissent is good. Dissent shows that people are thinking, they are independent, as you have just put now. So thank you, Raghib Sharia, for that question. We are already out of time by some margin, but I would still ask you one last question. Actually, a combination of two questions and somewhat unrelated. But I thought that is, one question is my personal curiosity, and another I think is relevant for many of our audience this evening. It's about the skill with languages, because many of our students, many Bangladeshi students these days are effectively conversant with English and of course Bengali as mother tongue. So we know that the other ICC's official languages, that's not an area of strength of most of our students. So does that somehow limit their options when it comes to, let's say, internship or other positions at the ICC? And quite unrelated, but my personal curiosity, it's about the relationship between the judges and others who work so closely with judges. Because in recent days, I'm sure you are aware that there's a growing body of literature, particularly in international trade law, in relation to the role that the WTO Secretariat plays. But also, I think it would be fair to say when it comes to ICJ. So do you have anything to share? I know that there will be many official secrecy and other issues. There will be your contract. But can you share some light that how does this relationship play out? Maybe a few words on that. Thank you so much.
Sure, sir. Firstly, with regard to the first question regarding languages, so the officializing the working language of the court is English and French. As long as you're competent in one of them, more in English than in French, because if you look at least in the past many years, most of the, at least in chambers, with regard to the judges, almost all of the decisions are exclusively in English. Rarely will you have a French decision. But of course, there are filings made by parties, particularly defense, which are in French. So you will need to develop, even if you don't have it at the beginning when you start your internship or your, let's say, or your employment or your position at the court, you will need to, with time, develop some level of competency in French, so that it's just easier for you to do your job. And in many situations, because many of the filings are confidential or secret, you cannot copy paste them into Google Translate and translate them. So one will need to get some experience in French. Also, but when you're working with French, automatically, because you're working with it, because there's a need, automatically you learn it by doing. But English competency is more important, especially English legal drafting skills and good command of English in terms of writing and understanding legal English. So it's not a barrier. It's not, I would not say it's a barrier. Of course, it helps. If you have competency in both English and French, then of course it's an added bonus. But as long as you are competent in English and you have the willingness to become competent in French, you'll be fine. So with regard to your second question, that is working dynamics. Actually, I've started reading the book that you suggested, that Everyday Makers of International. I actually have it here right now with me. I got it from the Peace Palace Library. So, like I said, I work as part of a team. So we have a certain number of legal officers who advise the trial, a chamber. So a chamber is composed of 3 judges. And our work is to basically provide the judges with the legal support and legal know-how that they need to render a reasoned decision. And we also help them with drafting those reasons as well. So there's slight differences between how, let's say, our chambers are structured as for example, as opposed to the WTO or ICJ. For example, in ICJ, there's a legal officer who works with 1 judge. So every judge has 1 legal officer working with them. So there, the relationship and the dynamic is a bit more different, because for us as a group, we work with the judges, and the judges are also technically a group, at least a tribunal in that sense. So the dynamic is different, and it's more, the relationship is, the analogy that I use generally to explain this is, we are sort of, and the book also talks about this, we are more or less legal bureaucrats. We, in many ways, ensure continuity of the court in terms of providing proper, adequate, sufficient, efficient legal advice to the judges on various points of law. And it's our job, it's our work in many regards to research the law and check, okay, so this is an issue that we are facing in our case. How was this issue dealt with by past trial chambers or past pre-trial chambers? Or are there any appeals chamber decisions that have clarified this issue? And then on that basis, we basically advise and assist the judges. That's the best I can do in terms of describing the kind of work that we do in chambers as legal officers. Sorry, sir.
Thank you so much. Thank you so much. Thank you for that answer, and also for your lecture and dealing with all the questions. Have a good day.
Thank you, sir. It was a pleasure, and thank you all for the questions as well.